Thank you, everyone. Please be seated. We're here this afternoon for the case of Hora versus Hora, and I want to make sure that I've got that we're all on the same page. Mr. Lorentzen will be arguing for Brian and Greg. Raise your hand. Okay. And Mr. Carls for Keith and Lori.
Correct.
Thank you. And Mr. Yonkers for Kurt and Heather.
Correct.
Okay. And then also the order of this event will be Mr. Carls, then Mr. Younker, each for 10 minutes, and then Mr. Lorentzen for 15. Is that how you guys are so far? And then we'll go back to the 5-5 with Carls and Younker. Okay. Just want to make sure we're on the same page. It's not as typical as we normally go. All right. We will begin with Mr. Carls.
Thank you and good morning. May it please the court. I represent Keith Hora in this derivative action and shareholder action brought against him by two of his sons, Brian and Greg. I want to begin today with the misinterpretation at both levels below with respect to Business Corporation Act Section 741, derivative standing. By enacting this section, the Iowa legislature sought to safeguard corporations and their stakeholders and their rights from individuals who are not suitable to assert them, or that by asserting them would do those people harm. This protection is justified for at least two reasons. First, it represents a rare instance where the decision-making of a corporation is not being controlled by those invested by its shareholders to make it. And second, because derivative action is, as an assertion of corporate right, also binding on that corporation.
I agree with you. Derivative action is not a way to air out management disagreements, and we'll get to that part. But, you know, I guess why not? Why wouldn't it be? I mean, the reality is if your clients pay damages, it'll go into the corporation, and only a small percentage of that would then, I guess, ultimately inure to the benefit of Mr. Lorentzen's clients. But that's their choice if the court concludes that the corporation's been harmed by your client's conduct. Why wouldn't there be standing?
The question is, why have a statute specific to shareholder standing and fair and adequate representation at all if all we're going to do is say that by definition the claim is going to benefit the corporation, so it has to be fair and adequate representation? Presumably the legislature meant something when it enacted this statute, much more than just suing out on a derivative claim is going to benefit the corporation, and so anybody who does it is fair and adequate representation. And that's the problem with that thinking, which is what was applied below, and even more critically to what was applied below, it wasn't even the corporate interest that the district court and the Court of Appeals looked at. Their findings were based on, well, it could conceivably benefit all shareholders. But the text of the statute doesn't say, well, it's a shareholder rights case or it could benefit shareholders. It says specifically we are asserting corporate rights and advancing corporate interests, which is why when we get into this disqualification dissolution rule.
Position, there's sort of a certain minimum percentage of stock you have to own in a close corporation before you can bring a stockholder derivative action?
There is one share. You have to be a shareholder. That's subsection A of 741. Correct.
I mean, I always understood this suitable and adequate representation to be things like, you know, do they kind of like in a class action? Do they have the funding to hire the lawyers? Do they have are they subject to is there a conflict of a legal conflict of interest, not a business disagreement? Is there a legal things like that? not sort of a judgment call by the court. Well, you know, they leave things alone because they only control a small percentage of the stock, and the people who control most of the stock like the way things are going. That strikes me as kind of a loose test to apply, and not the one we were intended to apply.
Well, I do think there are parallels to the shareholder class scenarios. We've cited you to two cases, the Beckworth case from Connecticut, which has an 8-factor test talking about what is fair and adequate representation of corporate interests. We've also cited you to the Fuqua case from Delaware that deals with the same. It's another 8-factor test. They're slightly different. And when you look at those and you look at the court's analysis in applying those tests, what they're looking for is, are these minority shareholders acting on the best interest of the corporation? Are they trying to vindicate corporate rights? Or do they have conflicts of interest in the actions they're bringing and with the people that they're bringing them against?
That they are also seeking relief that involves dissolution of the corporation, and that in effect would disqualify them from being proper derivative plaintiffs to help the corporation?
But it's a problem. I'd hesitate to enact a bright line dissolution, disqualification, custodian disqualification rule, because I'm sure we could all create cases where maybe that would not be such a right rule, even though for the majority of them it maybe could be. The point of that line of cases, that's the Reed case out of Wisconsin, is that you can't pretend to be advancing corporate interests. A guardian who wants to kill his ward is not the best guardian for that ward. And in the same sense, when a shareholder wants to bring death on the corporation through a dissolution, it's hard for them to be pretending to advancing that corporation's rights.
It was my understanding that Brian and Greg had abandoned a claim for dissolution. Is that not correct?
After trial, they abandoned it after they understood the consequences of litigating that question for 3 to 4 years. They also have not dropped the request for custodial control, which is just as prejudicial to a company. Short of death, it's like putting the company on forced life support. We're saying the nervous system of the company, its corporate directors that are elected by the shareholders, the officers that the directors then select, are cast away, and that central nervous system is then imposed on the company by a judge. That's a
When is that determination made? Is it a pleadings issue? When do we decide derivative standing?
The statute answers that question. It says in its introductory clause, to commence and maintain the action, you have to satisfy the two elements we're talking about. So it's a question that applies not only at the pleading stage, the commencement of the case, but it's a question that applies through the maintenance of the action itself. It's a question you could determine today, here at the end of the case. It's as applicable now as it was at the beginning. And that's my answer. The other thing that's interesting here from a conflicts of interest standpoint is that it's not just this remedy that they've pled out both corporate and shareholder actions that are in conflict with each other, but the causes of action that they've alleged on behalf of the company, they themselves have conflict with. The trial record, perhaps the most specific findings that Judge McPartland made were about Brian and Greg's, the plaintiffs' participation in the very conduct that in this suit they say is wrong. And so we have this conflict with their cause of action where you have to say, well, if it was really wrong, why aren't you listing yourself as a defendant? And if by not listing yourself as a defendant, are you then conceding that there isn't anything wrong to begin with? And it's this inherent conflict that when we're looking at fair and adequate representation, particularly in family cases where we have this history and participation knowledge amongst shareholders as to what's going on, it's important to root that out.
Let me turn to something else, because it did, sort of reading the Court of Appeals, it did seem to be kind of a muscular approach to reviewing a lengthy trial that had been conducted by a business court judge. Is it correct that your client personally guaranteed was on the hook for the debts of the corporation? Is that correct? Yes. And that, it strikes me as a significant fact in analyzing all the transactions, because that would, I understand there were financial difficulties, but to the extent there were financial difficulties, your client is the one that unlike the others, is the one that ultimately would bear the consequences. I didn't see that analyzed in the Court of Appeals. Am I correct?
Calling the analysis on review muscular is a bit generous, but no, that did not factor in to the Court of Appeals decision, at least as I read it. I do believe it factored into Judge McPartland's decision at the district court level. It is mentioned in his trial ruling, and presumably was one of the reasons he dismissed all of the claims after watching 11 days of testimony and reviewing thousands and thousands of pages of exhibits for a year. He got to see the family witnesses testify, and his result inherently includes credibility determinations based on what they saw, including testimony that there wasn't any stolen corn here.
Like you're already over, if you want to summarize.
In some, the legislature intended that its restrictions on derivative standing would have real effect, or it would not have enacted them. And I would ask this court for the first time to interpret the statute accordingly and dismiss the claims that Brian and Greg have made for lack of standing. Thank you.
Mr. Younker.
May it please the court, Madam Chief Justice, counsel. I've come prepared to talk about two issues on further review, but I want to begin with de novo review and pick up with Justice Mansfield's comment that the Court of Appeals opinion appears to be a muscular approach to a lengthy trial ruling by a business court judge. And that summarizes one of the main mistakes that led to the appellate court's determination that Kurt Hora stole corn, because that's what the case is about. Brian and Greg Hora alleged that Kurt Hora stole hundreds of thousands of bushels of corn over a period of years. The Court of Appeals determined, reversing the district court, erroneously determined that Kurt misappropriated that corn. And that's despite the fact that Kurt Hora's compensation practices were the same compensation practices that Hora Farms had followed for decades.
I get that point. What do we do with the fact that this form of compensation doesn't seem to have been reported anywhere? There wasn't a 1099 or there wasn't a W-2 for it. What are we supposed to do with that? The Court of Appeals had a problem.
A few different things, Your Honor. Number one, this isn't a tax case. The trial court record is not developed on the propriety or the impropriety of how the compensation system should be viewed from a tax perspective. That wasn't a claim in the case. Number two, what is in the trial record is a record that Brian and Greg also apparently were not reporting, or at least had a similar tax treatment during their times involved with Hora Farms. Number three, Your Honor, even, and we don't concede the point, but even if there were transactions that were not reported from a tax perspective, that doesn't mean the corn wasn't compensation. And I think it's important to keep in mind the two parts, the two components of the payments that Kurt received from Hora Farms. One part was compensation, so compensation for the services he performed for Hora Farms. The other part of the payment he received in corn was reimbursement. Kurt's farm, his farming operation, HK Farms, would provide equipment that was used in Hora Farms. HK Farms would hire labor that was used in Hora Farms operations. So part of the payment was a reimbursement. And I don't know, I'm not a tax attorney, so I don't know when we look at the available deductions and how those transactions flow back and forth. We don't know what the tax treatment was, and it was not a subject of the trial court's record.
Am I correct in understanding? So your client, Kurt, was an employee, not an officer or director during the relevant time period. So he owed an agency's duty of loyalty, an agent's duty of loyalty. So he couldn't misappropriate, but he wasn't subject to that sort of broader duty to look out for the overall best interests of the corporation. That's up to the officers and directors. So what we would have to do is focus in on, was there a breach of this narrower employee's duty? Is that correct?
I believe that's 95% correct. I agree that the broader concerns of the management of Hora Farms, that fell to its managers, that fell to its officers and directors. Kurt was not an officer and director. The point I quibble with is the duty that Kurt had, and this is outlining the Condonado case. There's a duty of loyalty that's implied into every employer-employee relationship. That's our default, our garden variety employment duty of loyalty. There could be an agency relationship that could give rise to a higher duty of loyalty, perhaps fiduciary. We do not concede that Kurt was an agent, and that's been a through line through all of our briefings in this matter. We concede that he has the duty of loyalty that's implied in every employment relationship. We don't concede that he has the duty of an agent. And if he has the duty of an agent, we don't concede that runs through all of his
duty of loyalty as an employee. Does mismanagement ever rise to a violation of that duty? Or do we have to agree with the Court of Appeals that he was actually misappropriating the corn?
Mismanagement, and we don't concede there was this management, of course, that'll be a duty of care issue. That's not a duty of loyalty issue. Especially, sorry, Your Honor.
Kurt was responsible for making all of these year-end settlement, coming up with the documentation, or, making those determinations of the amounts and what would effectively then be his compensation. There's no level, if he would have just written, numbers on a piece of paper with no explanation at all, that still does not violate the duty of loyalty.
Well, two things, Your Honor. That's not the record we have. And returning to the de novo review issue, we have a well-developed record with witness credibility assessments that doesn't lead us there. Number two, Condonado sheds some light on this, because in the Condonado case, this court said, the damages that were alleged regarded to failure to perform. They regarded to lost profits. So they were in regard to how the employee was performing his duties. In other words, mismanagement and not doing his job. And the court in Condonado said, that's not a duty issue.
And I'm following up on what Justice Oxley was asking about, that if your client is helping himself to corn, but that's generally known by the management of the company and generally accepted by the management of the company, the fact that that might not be a great way to overall manage the company, to have people taking corn that's not accounted for exactly, that would not be a breach of his duty as an employee. Is that your view as well?
Correct, Your Honor. Hold otherwise would call into question the practices, I'm sure, of family farms across the state. I don't believe that the Accounting on family farms across the state is down to the kernel of corn. Returning to de novo review, in this case, Judge McPartland, sitting in the business court, heard testimony for over 11 days, and he made specific findings regarding witness credibility. That's the first part of our de novo review argument, and that's important and that means something. The Court of Appeals did not pay appropriate deference to the witness credibility determinations. The second part of our argument deals with the other reasons de novo review and deference to the district court is important. And in this case, two are of particular importance. One is judicial comity. We do have a specialty business court that has a lengthy developed trial record. And Justice Mansfield, again, as you said, the response to that was a muscular one from the Court of Appeals. And number two, the cases have undercurrents. And the trial court is in the better position to tune into those undercurrents. And in this case, that's especially relevant because this is a family farm. It's not a larger corporation. The issues were internal, relating to family members, and so those issues should be accounted for in the Court of Appeals' opinion.
I couldn't agree more with you, and have written similar things in divorce cases about our deference to the district court, and yet when you're on the Court of Appeals, you have this duty of de novo review, and how do we exactly articulate where the line is and how much deference we should give to the district court's fact findings, because ultimately we also say it's de novo review from the Court of Appeals point of view, and they review the whole record and come to their conclusions, and sometimes they differ with the district court on lots of things through family cases, as you reference.
I think it's important. Let me answer the question this way. The Court of Appeals should show its work. And so there's a difference between paying deference and disagreeing under de novo review, coming to a different conclusion, and ignoring and not considering. Deference requires considering, and it requires showing work if you come to a different conclusion. And another approach to the issue would be substantial equity. Stepping back, was substantial equity done at the district court level? And I think if you look at the witness credibility determinations, the well-developed record, the fact that the 9 bushel per acre or per hog assumption was a bargain for exchange, substantial equity was done. But the real issue here is that the Court of Appeals did not show its work and came to a conclusion completely opposite of the district court with no explanation. I see that my time is up. We urge this court to vacate the Court of Appeals and affirm the district court. Thank you.
May it please the court, counsel. The review that was conducted by the Court of Appeals was not necessarily muscular or robust. It was de novo, which is the form of review which my clients have a right under the Constitution.
There's another, I have another issue potentially with what the Court of Appeals done. You know, I was on the Court of Appeals for a couple of years, and you know, you have de novo review. You review the case. If on de novo review the panel determines that the case was wrongly you redecide the case. That's kind of not what really happened here. The Court of Appeals in this case redecided some issues and then sent it back for the district court to, you know, kind of finish the work using, you know, using these legal issues that the Court of Appeals had resolved differently without actually applying that law necessarily to the facts in full. So it's sort of, it seems to me it's kind of an odd sort of in a case where there was a bench trial and a de novo review, it's kind of an odd opinion. It's sort of a 50% review. It reverses the ultimate outcome, but doesn't say where the case should ultimately land. And it just strikes me as unusual.
is a problem or a concern that this court may remedy by conducting a full de novo review. If the concern is that the Court of Appeals didn't perform their function fully, this court may do so under the Constitution.
De novo review, why shouldn't we give considerable weight to the credibility determinations of Judge McPartland, who heard the testimony firsthand?
There were only a very few credibility determinations. Much of the time, reading Judge McPartland's decision, you'll see that he found the evidence was uncontested. There were a couple of credibility points he made with experts never explained, other than the fact that one of the experts hadn't grown up on a farm, an expert who was a certified fraud examiner.
Point, one of the experts put a lot of weight on the lack of reporting in tax returns to support, the conclusion that the corn wasn't really compensation, or the payments to Keith were not really compensation when they paid his personal expenses. Was the issue about inaccurate tax returns and the problems that that can lead to, was that presented as part of the breach of fiduciary duty itself because they were not properly preparing tax returns, or was that just used to show kind of the side thing that really wasn't compensation because it wasn't reported?
Honor.
And as one of the issues of the breach of fiduciary duty by Keith was that he improperly prepared tax returns, or at least provided inaccurate information so that those were inaccurate tax returns?
There hasn't been damage from the inaccurate reporting of tax returns in the form of adverse action by the Internal Revenue Service. That hasn't occurred yet. But the breach of fiduciary duty, a duty, in other words, to accurately report what the financial information of the corporation is, clearly occurred, number one. And number two, it cast complete doubt over the explanations that had been offered by Keith and Kurt as to why all of this corn was missing. We're not just talking about minor errors. We're talking about a third of the production of a farm that's over 1,000 acres over a period of years. Over 200,000 bushels were admittedly missing. In other words, Keith could not report where those bushels went. And the only explanation that Kurt gave, and Kurt, on this point, Kurt is not just an employee. He is not a farmhand. Kurt was the operations manager, he was the grain manager, and he was the person, like a treasurer would be, responsible for preparing accurate information about where the production
he was not the treasurer of the corporation, was he? He was just, okay, but he was an employee.
He was a manager. He was employed, but he was a manager, and
says that an employee manager has a higher duty than an employee.
We cite that case in our brief. I believe it's Condon. And the issue here is, what is the level of responsibility? Like I said, he's not a field hand. He's not just told what to do. Rather, he's the one who is accounting for the operations of the corporation. Good example, 2007, when an audit was done, which I believe you could conclude on your de novo review was done because Keith started to realize that he was losing control over exactly where everything was going in the corporation. And it was Kurt that conducted that audit. And it was Kurt after that who was responsible, actually before and after, who was responsible for properly accounting for where all of the grain was going, where all of the expenses were being incurred, at least with respect to when he was paying expenses for HK Farms. He was a fiduciary. And a fiduciary is someone who has that level of control in other words, from an agency that requires accountability, unlike the field hand, who is simply required to do what he's directed or she is directed to do during the day and go home at night. That is not the role that Kurt had in this operation. It is never the role that he had since he started in 2002 after Brian had left.
Change gears a little bit. In your briefs, you rely on the 490.860 conflicted transaction kind of standard. Was that argued at the trial before we got to the 1904 motions? Is that the standard that was used, or was it more of a general conflict of interest?
The argument that we used that had anything to do with the 861 standards, it was simply because there are certain principles of fiduciary duties that are incorporated into the standards that apply to directors. But we are not bringing a claim against Keith or Kurt based on any particular action as a director. Those arguments were based on fiduciary principles and conflicted transactions.
Question. So 860 and 861 specifically addresses conflicted transactions and how you can resolve those. Did you bring, against directors, exactly. Did you bring a conflicted transaction claim against Keith, or was it just more the 830 line of breach of fiduciary duties?
The claims that were brought were for breach of fiduciary duty. As I said, we are not bringing any claim against Keith for an action that he took as a director that must be analyzed strictly under any of the standards of liability that apply only to directors. He was a president, he was an officer. He also controlled the corporation by having the majority of shares, and his fiduciary duties at common law rose out of that. But in looking at the duties and standards of liability of a corporate officer, the principles that are announced in 830, 831, 832, those sections, are only for reference. And 860, 861, those are defenses, which were never raised by Keith. At no time did he raise those as defenses.
Since we're talking about Keith, so as I understand it, there's sort of basically two claims against Keith. One is these personal expenses that were paid through the corporation, and that amounted, as I was doing the math, it's something like $20,000 a year. Is that right? Is that about $190,000 over in the vicinity of 9-10 years, something like that? Well, he's guaranteeing all the corporate debt anyway. And he was only being paid about $10,000 in salary during that time. Is that correct?
I think that's what was reported, yes.
Was there evidence that he was being paid anything else?
No, Your Honor.
Then there's the issue about the son, you know, and the misappropriating or missing grain, whatever is characterized. Isn't that really just a management issue as far as Keith is concerned? He didn't personally take the grain, did he?
To be taken.
Why wouldn't that be just a management issue subject to the business judgment rule? You know, that was an arrangement they had, and that was, you know, I think even Judge McPartlin agreed it was not a particularly good business arrangement, but it wasn't something that would necessarily be you know, corrupt or anything like that. It's just a bad business judgment.
First of all, transactions involving conflicts of interest, which were the transactions that were occurring between Keith and Kurt, are not subject to the business judgment rule. And
the whole corporation's a conflict of interest. Everybody's is a family member, right?
That doesn't mean what they do is wrong. It just means they have to account for it.
So that means in a family farm where everybody is family, you're going to impose a much higher obligation of sort of accounting for things than you would if it was just a business out on the street where the people were not related to each other. Is that what you're saying?
Farm chooses to operate as a corporation, then the family farm is required to follow corporate rules of operations. And the rules are no different between family farms and corporations which don't involve closely held family organizations. The rules are the same for all of them. Keith could have chosen to have someone else as the manager of operations other than his son. He could have chosen to have someone else as the manager of grain. And there would have been a standard that would have been appropriate there, because if there was an arm's length transaction between them, then it wouldn't be subject to a conflict of interest transaction. But in this case it was, and the business judgment rule doesn't apply. The other reason the business judgment rule doesn't apply is for breaches of the duty of loyalty. Never applies to breaches of duty of loyalty. And when Keith favored Kurt in ways that were so substantial that over this period of time that you're looking at, the corporation had to incur an additional over $2 million in debt because they never had operating, working capital, because Kurt was feeding as much corn to HK Farms pigs as he wished to. It wasn't it wasn't the deal that he could feed whatever he wanted to. He was supposed to account for that, and he wasn't. This rule of thumb that they had about 9 bushels, it was, first of all, never investigated by Keith, but it wasn't accurate. Clearly it wasn't accurate, and Keith knew that by the own records he kept.
Accuracy seems to go to kind of management as opposed to knowingly stealing corn.
Not when there is a conflicted transaction like this.
Why I asked you specifically whether or not whether you brought this as a conflicted transaction. I understand you're saying that Keith didn't defend it that way, but you didn't raise this as an 860 conflicted transaction at the trial court, right?
Only applies to claims against directors, and we brought claims against Keith as a officer.
Appeals relied pretty heavily on the 860 rules with respect to some of their findings. So were they wrong about that?
Because these rules that we're talking about, even if they don't apply to officers directly in terms of determining standards of liability, they are based on principles of fiduciary duty. And if you look at the last sentence of 842, which applies to standards of conduct for officers, it talks about how do you impose liability on an officer, and it is common law, and it includes looking at the 830, 831 standards and the principles that they employ. But you don't have to strictly follow those rules in imposing liability on Keith here. I see my time is up. We ask that the relief requested by Keith and Kurt be denied, that the case be decided de novo by this court. Thank you.
$860 was not raised until after McPartland's decision made his decision. That's clear. We never had an opportunity to address that at the trial level, nor were we accused of doing things wrong with taxes. That wasn't an issue in the case until the appeal started. It seemingly was the shiny thing that might get somebody's interest for Brian and Greg. Of course, Keith is entitled under the statute, I don't know the subsection offhand, but he's entitled to rely on the accountants who give him the advice on what to report, what not to report. We weren't able to develop that because it wasn't raised. In listening to the arguments, the question that I'm coming back to is, where is the line on de novo review? I mean, that's big picture on the merits of this case. What is that? I think there are three things, three components. The first is it's review in the sense that you're not deciding new issues, you're deciding issues that the litigants raised below. And you're not, as a judge, raising issues on your own that you're interested in, that you think apply, that may apply to the case, but weren't raised below. That's the first component of de novo review. The second component of de novo review is you actually have to do it. When you say you're doing a de novo review, you then have to do the de novo review. You can't just do pieces of it, take a little bit here, borrow a little bit there, send it back down for completion. You need to do a de novo review. The third thing, and this is perhaps the most important thing in my view, is that as an appellate judge, as this court knows, you don't get to see the testimony. You can't see Brian and Greg looking at the binders of questions they're going to be asked on direct exam. You don't get to see Kurt testify that he didn't steal.
The credibility issue, I want to make sure I have it right, is I went through the district court opinion. I saw a credibility determination somewhat against Brian, in favor of Mr. Buckert, in favor of Mr. McNutt, and adverse to Mr. Schnur and Mr. Bold. Are you aware of any other credibility determinations made?
Yes. The credibility determinations that are impacting the decision. You know, it's like saying, because balls and strikes weren't specifically called in the ruling, there weren't any pitches. There weren't balls, there weren't strikes.
Says out loud in his ruling, makes those credibility findings. Are there any other ones than the ones articulated by Justice McDermott in writing or on the record?
I'm not aware of any. I would have to reread the opinion, right? I'm not quibbling with you on specifics of what was said and what wasn't.
That where there was a conflict and the judge ruled a certain way, it shows that the judge believed one witness over another one. I just want to make sure that I think, captured the ones that were explicitly stated.
There was this tension between the court finding that Sue Bastion is credible when she's saying Greg told her to cut off the farm's operating financing. He found that testimony credible. Greg testified directly to the contrary, and so in finding the bank president telling the truth, she necessarily found that Greg lied about a material issue in the case. But the point for de novo review is, because you don't have the record, you don't get to see, there are some things we can't send you in a paper record. Where those issues can...
Make sure I have the list right too. From my notes, I had the farm credit person, McNutt, the consultant, Bastion is the bank president, and then there were some aspersions on one of Brian, I think it was, and then there was criticism of the credibility of the two outside experts brought in by the plaintiffs. Is that correct? Okay.
The problem that I have with sort of counting as you're doing is that the fact finder watching it, there are plenty of things you're seeing that you're processing that are built into your judgment that you're not necessarily articulating.
You put it in writing or say it out loud on those determinations. And of course, we're balancing 100% of the time, the rest of the time. So doesn't it deserve some additional attention, the fact that those were called out?
No, and I think I would actually tell you not to put that in your ruling, because then what you're doing is you're effectively telling the district court judges, you want this to stand, just call credibility however you see fit. I think there's risk in doing this counting exercise rather than telling appellate judges, look, where the testimony could influence the decision, where watching the testimony has an impact on material issues in the case, you need to be deferential to the trial judge's determination of those issues because he's the one watching the testimony, even if he didn't call balls and strikes the way they could have been called. And so, I think that's my time. I see that I'm flashing. Unless there are any
Okay, thank you. We're back to Mr. Younker.
Thank you, Your Honor. This may be ambitious, but I'm going to try to cover 3 issues in the time that I have. But I'm going to pick up where Mr. Carl's left off. Because I think there is a balance here, right? And I do think, Justice Manfield, I think we have the list correct. Bryan, Buckert, Baston, and the 2 experts. Those are the witnesses for whom Judge McPartland made particular findings of credibility. And there is a balance here between the specific witnesses and the case as a whole that Mr. Carl's discussed. And I think that there's one issue that's important to the case that's a good one to bear in mind, and that's this 9-bushel assumption. Because in this case, we have particular findings from Judge McPartland that Kerry Bolt, plaintiff's expert, is less credible than other experts. And he's the one who's critical of this 9-bushel assumption. On the other hand, we have Kurt, his testimony, the testimony of his experts from Big Gain, Kurt's settlement sheets. And so necessarily then, because of the finding that Kerry Bolt is less credible than other experts, Judge McPartland necessarily determined that the criticism of the 9-bushel assumption didn't bear weight. It didn't hold up under scrutiny. And that's important in this case because a large part of plaintiff's theory is that the alleged missing corn was all because of this 9-bushel assumption. And the 9-bushel assumption, of course, is a red herring legally, because it was a negotiated for term in Kurt's compensation, but it also doesn't hold up factually. And so I think that's something that's important for this court to take a look at when it looks at what level of de novo review is appropriate and how that de novo review affects the case. Judge McPartland was sitting on the bench, receiving the testimony, reviewing the exhibits, and he made very specific findings of facts that impact the case in a significant way. Mr. Lorentzen said that Judge McPartland made just a few credibility determinations. We've identified those. It's significant that one of the specific individuals that Judge McPartland found not to be credible was the plaintiff, and that permeates the case. That's part of the de novo review and giving deference because that permeates other aspects of Mr. Bryan Hora's testimony. I want to talk a little bit about if Kurt is an agent. And again, we don't concede he is, but I think it's important to note Mr. Lorentzen was asked, what's the case that says Kurt Hora is an agent? He said it's condenado. We talked about condenado a little bit when I was up here before. I don't think that gets Mr. Lorentzen where he needs to go. But here is something else to consider, the Hilgendorf case cited in the briefing. Kurt wasn't an agent when he was negotiating his own compensation with Hora Farms. When he negotiated his compensation and Hora Farms and Kurt agreed to the 9-bushel assumption, Kurt wasn't an agent. That's an arm's-length transaction. He's negotiating terms of employment with his employer. That's the Hilgendorf case. And again, there's nothing in the record to establish that HK Farms stands in an agency relationship with Hora Farms. So these reimbursement transactions that we've talked about, they're outside of any agency analysis. And I think it's important that the court keep that in mind as it takes a look at the case.
So quickly, what role does 490.861 play in a defense for the defendants in this case?
With all the issues in the case, I'll defer to Mr. Carls and his presentation of that argument. I've been focusing on the issues as they relate to Kurt, and I don't know that they relate to Kurt as the case was tried at the district court level. That wasn't an issue that was brought up against Kurt at the district court level. And I see that I'm nearly out of time, so unless there are further questions, again, we urge that the Court of Appeals opinion be vacated and the district court opinion be affirmed. Thank you.
Hora is hereby submitted, and the court is recessed for the morning.